Hello everyone. I would like to welcome you to join today's webcast on sharing information requirements when working with service delivery partners. Before we get to the webcast presentation though, I wanted to mention that these webcasts are part of a larger joint initiative by the Government of Alberta called the Community and Social Services Learning Series. For more information about this series, check your emails for regular updates or go to the CSS Learning Series.ca. You'll be able to pose your questions to me directly through our live chat window. If you have yet to access the chat, I would recommend that you try it out now. Scroll down from your main screen, the viewing window, to find it. I will address as many of these questions as I can at the end of the presentation. Nicole is our online moderator. She will pose your web chat questions to me at the Q&A period at the end of the presentation. Today's presentation is also being recorded, and the video will be posted on the csslearnings.ca website about 2 weeks after the live session. Now let's get started. Today I will be covering some of the areas that impact and allow for the sharing of information as you work with your partners in a collaborative or in an integrated manner. The objectives for today are listed here. So we're going to be reviewing the purpose and the vision, the whole notion and the reason why we developed the information sharing strategy, and what it is that we hope to plan on achieving through this approach. Second, we want to be able to describe what the information sharing landscape looks like and how you can work your way through it. Third, we want to talk about how you can use specific skills to make the best decisions possible about sharing information and when to share. And finally, what some of these practices look like when they're applied within a collaborative service cluster. Now, the strategy was first developed as there was a recognition that staff working within service delivery organizations within social service sector environment, and that's a mouthful, felt that they were hampered in being able to provide the best outcomes possible and the best level of service to their clients as they worked with other partners, due primarily to the various pieces of privacy legislation and the way that they were being interpreted, and the fact that people were very confused about how they interrelated and weren't sure about what decisions they could actually make. The mandate that we were given was to ensure that information sharing practices would be implemented in a way that allows government organizations and their partners, agencies and other organizations, their service providers, to share the information that is necessary to achieve the outcomes that are being identified through the client-centered and coordinated or comprehensive case management approach. As we undertook this work, we did a fair amount of consultation and heard a number of things. We heard that staff working within the social services environment were extremely committed to the work that they do and to doing their very best to deliver good outcomes and supports. However, we also heard that they felt that they were not able to achieve those outcomes, to achieve those goals, or to achieve the commitments that they were making because of their inability to share information. So when we first started this, we took a look at the organizations that needed to be involved. And primarily, we started out with the core organizations, and we went to Cabinet, and Cabinet approved the implementation of a strategy, starting in a phased approach in 2013, across 3 ministries and their stakeholders. Those ministries included health, education, and what was at the time human services. Since that time, human services has been split into 2 ministries, children's services and community and social services. But the programs remain the same, and the commitment to work together remains the same. We soon realized, though, that there were other organizations that needed to be brought into the fold. And when I talk about those ministries, it's not just the ministries or departments themselves, but it's all of their partners and stakeholders as well, including all of the organizations that we contract with or work in partnership with. We decided, though, that we needed to bring in some of the other ministries, and so in 2016, we invited Justice and Solicitor General and Seniors in Housing to also join us, because we were working quite often across their programs as well and needed to ensure that we were moving in the same direction at the same time. Now, as you can see on the slide here, we have a number of ministries that are engaged. There's 7 ministries identified here. The last one to be added was Service Alberta, and they're a bit of a foundation for us because they are responsible for the Freedom of Information and Protection of Privacy Act, or FOIP, as well as the Personal Information Protection Act, which is the one that applies to the private sector. Early on, we heard a lot of discussion about the need to remove silos and to get rid of silos. However, what we've found is that the silos exist for a reason. They really aren't silos as much as they're areas of focus. There's different ministries that have different mandates and different areas that they need to focus on in order to ensure that the programs are being delivered appropriately. What we need to achieve, though, is that there's a coordination or there's alignment and that there's work to be done to pull the different pieces together and that the touch points between these ministries are actually put in place. So the focus then is to work together across all of the ministries and ensure that we are able to collaborate wherever we need to support those good outcomes. Now, the slide in front of you is where we start talking about privacy legislation. And as you can see, there's quite a bit of a landscape here, and it gets very complicated very easily. We have a number of pieces of privacy legislation in play in Alberta, and I'll go through them relatively quickly, but it is important to understand that they exist and they have different application to different organizations, and that sometimes is where the complexity comes in. We have both provincial and federal privacy legislation, and while we tend to work within our own areas and often only look at the legislation that applies to our own organization, it is important when we work together, when we work in a collaborative or in an integrated manner, that we understand that there are sometimes issues that arise because of the differences through the privacy legislation. Now here in Alberta, we have primarily the one that we deal with the most is the FOIP Act, the Freedom of Information and Protection of Privacy Act. However, we also deal and work with our health care providers, and the health care providers such as Alberta Health Services, doctors, nurses, and so forth, all come under the Health Information Act. And that piece of legislation is significantly different in many respects from the FOIP Act. We also have the Personal Information Protection Act, and that one applies to the private sector. However, it's not totally encompassing, and we have organizations that fall outside of that legislation even, and that is primarily the not-for-profit sector. Finally, we also have the Privacy Act in Canada, the federal legislation. And the reason that we look at that is we have partners here that also are our federal partners. The RCMP as an example. We have organizations like Health Canada that also play a role. And so we need to be able to take a look at the impacts of that privacy legislation. It behooves us to really take a look at the barriers or the impediments that exist because of the legislation, and quite often because of the interpretation of the legislation. There are constraints that are created. So I'm going to give you an example to walk through how this might apply. Because it becomes even more complicated for our service delivery partners, the agencies that we work with. I'm going to choose one that is fairly large, robust organizations. Let's talk about, as an example, Catholic Social Services. Now, CSS is an organization that is a not-for-profit organization, but they do enter into contracts with various organizations. So we may contract with them to provide some services. And those services, through that contract, are pulled under the umbrella of the FOIP Act, which means that we as a public ministry have to ensure that the services they deliver for us are done in a way that allows us and ensures that we continue to be accountable for the information requirements under the FOIP Act. It doesn't mean that Catholic Social Services is under the FOIP Act. It means that through the contract we extend our authority to them. They may also contract with a healthcare custodian under the Health Information Act. So that agency now, through the contract again, gets pulled under the HIA, or the Health Information Act. And for that reason, they need to be able to understand the application of that legislation. But again, they're not a custodian under the HIA per se. They become an affiliate or an agency. They also do provide services on their own. So there is different types of fundraising that they might provide, raise money through in order to provide services. And some of those services are going to be on a sliding fee scale. So if, for example, they were to provide counseling on a sliding fee scale, well, that is deemed to be a commercial activity. And as a commercial activity, that pulls that activity under the Personal Information Protection Act, the private sector piece of legislation, which means that the information that is collected and managed through that counseling service is subject to PIPA. However, as an organization themselves, they are not subject to that Personal Information Protection Act. If they were to enter into contracts with the federal government, then as well, they would also be subject to the Privacy Act in the same way as I've described for the other pieces of legislation. Now, they're a fairly large organization. They can access teams of lawyers that can help navigate through understanding how this all makes sense or how it sometimes gets really complicated. Not all of the organizations that we work with have that level of sophistication or that degree of access to people that can help them understand how to make sense of all of this. And so it's our role then to ensure that as we work with the agencies, that the agencies do understand what it is that we're expecting, what it is that they're able to do in terms of managing the information. And we really do have to open the door and be able to talk with them about the types of issues that they're finding and how it relates to the services that we're being that are being delivered through that process. Now, as we take a look at legislation, we find that there is certainly some similarities and some differences. All privacy legislation in general speaks to the collection, use, and disclosure of information. And when I talk about information sharing, I'm really talking about those three elements. Taking a look at how we collect information, how we use that information, and then who it is that we might disclose it to in order to ensure that, again, the services are delivered properly. So there are some areas that are relatively similar under these different pieces of legislation. The disclosure provisions is probably the area that is the most different across these different areas. So if I take a look at the FOIP legislation, under the FOIP Act, we have, I think there's some 33 subsections as to when it is we can disclose information. Only one of them dealing with consent, the rest of them without consent. However, if I take a look at the Health Information Act, it has different provisions. It's a much narrower focus. And the reason for that is that the Health Information Act, when it was brought in, was really focusing on the health arena. So the organizations that work within the health sector, and the Health Information Act allows for the information to flow within that sector in what's called or termed sometimes as a closed arena. So health organizations within the arena are free to share the information in a way that supports the provision of health services. If you're outside of the arena, it's harder to get at that information. Not that it can't be done. So that probably makes sense if you think about it. You go and see your doctor, and the doctor is going to provide an assessment. Maybe they need some additional information, so they'll send you for some tests. The tests that are going to be done at the lab, maybe they need to have a specialist brought in. Maybe the doctor is going to prescribe some medications, and that goes to the pharmacist. All of those organizations are within the health sector, and they need to be able to communicate relatively freely. And there is what's called an implicit consent. In other words, there is the notion that the information can flow between those organizations in order to provide you with the services that you require. What we look at then is within our organizations, excuse me, how do we ensure that we're also able to allow the information to be accessed in a way that it provides the supports we need? So in the FOIP Act, there is a section, and I'm going to try not to be too technical in these areas, but it's important, again, to recognize what it is that authorizes us to move forward. So in the FOIP Act, there is a section that allows us to share information when we're working in a common or integrated program or service. What that means is that between public bodies, which are the organizations that are subject to FOIP, we can share information if we put in place a means by which we're going to work together, and we articulate what that looks like. Some of these organizations, and when we look at the various players across the services that we deliver, we see what are really patterns that emerge. So within the world of disabilities, we see that there's a pattern where we can identify typically the types of organizations that are involved, the type of information, the type of outcomes, first of all, that they're trying to achieve for the type of demographics or clients that they're serving, providing supports to. And they need to be able to take a look at then the type of information that is going to support those outcomes. What we've termed that as a collaborative service cluster. So it's typically the same sorts of things that we're seeing. From that, we're able to readily identify that it's the same type of information that can be shared in order to get to these outcomes, and that there's certain information that cannot be shared. We also look at the types of organizations because there are some that are very core to that. So we have the main players, if you will. The Persons with Developmental Disabilities Program is a main player within Community and Social Services. Alberta Health Services is usually quite involved with the delivery of services. Those become core players, if you will, within the services that are provided. But we also have sometimes there's agencies that we might make referrals to, and I'll talk a little bit more about this later about how we make those connections. But those agencies are often the ones that are going to be where there's a need for a different type of approach and where we might have to use consent, whereas in other situations we might not have to. The Health Information Act doesn't have that provision to allow for that integrated service approach. However, it does have other provisions that can come into play. One of those is that we have the ability to share information as a custodian to someone who is responsible for continuing treatment and care of the individual or their family. Early days, that was often interpreted to mean that it still had to be to someone who is in the medical field, that they had to be a medical practitioner. But when we dug into that, we find that, well, if you're a medical practitioner, you're already in that arena that I mentioned, and so you don't need to have that extra provision. And that provision really was to enable for organizations that provide supports to persons who may have health issues to get the information that they require when they're responsible on an ongoing basis. And that would include organizations that provide services such as certainly in the school sector. That means that the schools would be able to access information because they are responsible for the child while that child is in the care of the school. In our case, we are looking at things like group homes, service providers that deal with the individual on an ongoing basis, where they may need to know that there are certain health conditions that might impact the services or that might be dependent on certain things being put into place. And sometimes that information becomes critical to be shared. So I mentioned some of the, this is slowly going to come up here. I mentioned that there are provisions that in the FOIP Act, there's quite a number of provisions that do allow or support the sharing of information here. So as an example, we can use information for the purpose that it was collected or for use that is consistent with that purpose. When we look at that one especially, that needs to get back to, it has linked very directly to the purpose of collection. And quite often when you're dealing with a government organization, you'll hear from them that as we collect the information, that we're identifying a very specific purpose. So we need your information because we're going to provide you with the services under this program. Well, if we look at that and examine that closely, it starts to create a limit if we only talk about that one program. And if we talk about information being collected only for the use of staff within that program to provide you with the services you require, again, that's a very narrow approach. So one of the things that we had to do was take a look at how is it that we're articulating the purpose of collection and what is it that we're really trying to achieve. In the area of disabilities, under our ministry, we have a number of programs that deal with a person who has a disability. We have youth programs through the Family Supports for Children with Disabilities. We have the adult programs, including PDD, including AISH, or the Assured Income for the Severely Handicapped. Includes programs through income support. It might include the OPG, the Office of the Public Guardian and Trustee. And every time that we look at those programs and we collect information, we have to collect that same information again. So we are asking someone who has a disability or who has a disabled child to prove that they have a disability in order to be eligible for each one of those programs. And that really doesn't make a lot of sense, does it? So what we've looked at then is how do we better articulate what the purpose is? When we're looking at providing services to Albertans, we need to take a look at the long-term approach. So we need to understand where that information might be necessary to be used across all of our programs, across various organizations, in order to provide the best supports possible. And that means then talking about that purpose in a much broader way. So we're not just looking at a symptom, but we're looking at what is the life impacts of that disability and the services that we're able to provide through our programs. That means changing the way that we think. It means talking about a much broader purpose. The second one here is that common or integrated program that I've already discussed. And the other one is to determine eligibility for benefits or services. So we do have, again, a lot of different programs run by different organizations. And sometimes we have to be able to share information in order to ensure that that person's able to be determined, that their eligibility for that program can be determined. Our AISH program, the Assured Income for Severely Handicapped, has information that is collected from a medical perspective. And as we take a look at some of that medical information, then we can make an automatic decision that the person is eligible for PDD services in certain cases. Excuse me. The next piece is another provision that applies right across all of the privacy legislation. What it says essentially is that if there is an act that allows for the collection of information, authorizes the collection or the use of the information, then the privacy legislation automatically also allows for that to take place. So if we have an act like the Children First Act as an example, where it says that we can share information in order to provide for the best outcomes for a child in the best interest of the child in order to plan or enable the delivery of services, then we have authority in that legislation, and the FOIP Act, the Health Information Act, Personal Information Protection Act, and even the Privacy Act all allow for that information to be disclosed. So you don't have to always go back and forth between legislation. Also allows us to disclose information for law enforcement purposes, to assist with investigations, and to avert or minimize harm. The health and safety one is, I think, a particular one that is of interest to all organizations that work with individuals. When we first brought in those privacy legislations in Alberta, the bar was set fairly high. We had to have people deemed to be at imminent risk before information could be shared to avert that. We recognized that that was probably a bar that was set too high because essentially we had to be able to take a look at that person either being at risk of grievous bodily harm, and kind of right now, in order to meet that bar. And that's not often the case. So for children, now we've been able to change that, and now it's where there's a reasonable expectation of harm, then we can share information for health and safety reasons. As well, dealing with children, we need to be able to ensure that we're always meeting the needs of kids. And so we also have that last provision there to a law enforcement agency that is charged with providing services to a minor. Different organizations can share information when it's in the best interest of the child. The final one here is consent. So with consent, we can share information as well. That does not mean, though, that we can collect information only on the basis of that we have consent. We have to have a reason to collect information and provide that information, provide that reason to individuals when we are collecting their information. Now, as we start looking at the way that legislation works, it becomes important to think about the different things that must be considered. So, as an organization, what legislation applies to me? Because there is complexity in this, one of the things that we've developed is a resource, and at the end of the slide you'll see there's a link back to our website, and on that website you'll have a number of resources. One of those is a decision tree that helps guide you how to make decisions, and part of that is understanding what applies to you as an organization. So which piece of legislation typically applies. It's important to understand that because if I'm working in an organization that is under a contract to a public body, then I have to look at the contract, I have to be aware of what the FOIP Act says, whereas if I'm doing that on behalf of a custodian under the Health Information Act, the contract is going to be different, and some of the application is going to be different under the HIA as well. Or as an organization that is subject to that, so if I'm a public body person, staff, if I work for PDD, as an example, then it's the FOIP Act that applies, and I need to know that. I have to be able to take a look at what is it that we're trying to achieve. So what is the action that is being contemplated here? What is the service that is going to be provided? Do I have the rationale for that service? Do I have the authority to collect information in the first place? If I'm coming to you and I'm asking for your information, I need to be able to articulate or to tell you why it is that I need that information and how it's tied to the outcomes or the services that we're trying to provide. Do I have the authority to share that information? We need to take a look at all of those things. And this is really then where we start to need to understand, as we work together, what are the various roles and responsibilities that we all have? What is it that we're trying to achieve? What is my step in that process? What is my part in the outcome planning and my part in case management? And what information do I need to be able to have at my fingertips in order to provide that service, in order to provide the things that I am responsible for? And if I'm working with somebody in another organization and they're coming to me for information, I need to understand how they're going to use that information and what is their role when we're looking at a collaborative or an integrated approach. So that if I do have to disclose the information, then I understand why it is that and how it is that they're going to be using it. That is looking at all of those authority pieces. You don't necessarily have to understand all of the legislation, but we do have a responsibility as an organization to make sure that people understand how it is that we're deciding we're going to be working together and the types of information that typically can flow as we do that. But there will be times when you do have to drill in because maybe you're getting a request that just doesn't sound typical for the types of things that you're providing services to. And before we do all of that, we have to make sure that the clients that we're working with, the Albertans that we're providing supports to, that they have an understanding about how we're managing their information and how the information we collect across all of these organizations is going to be used in order to provide them with the supports that they require. It can certainly get complicated quickly. So when we look at the types of decisions that need to be made, well, there's a lot of things that go into that. So it's an understanding of the legislation to some degree. More importantly, it's an understanding of what the program is trying to do. And as we work across our programs, what is it that we're cumulatively trying to do? What is it that together we're trying to achieve in the way of providing supports, providing the outcomes that are created, often defined through a coordinated or comprehensive case management approach. And that means working with the family, working with the client, working with the Albertan to identify what is it that they require in terms of supports, and then how can we support those needs in order, in order to achieve the best outcomes. It also means using the skills and abilities. We hire staff for a reason. Staff have professional expertise. They've gone to school, they've become educated, they have experience in the field, and we want to bring all of those pieces together along with the understanding of the program and the outcomes that we're trying to achieve, looking at that shared responsibility we have across those other organizations we work with, and then determining what is the best path forward and making good, solid decisions based on all of that coming together. One of the things that we have often talked about is As we work collaboratively, as we work, whether it's anywhere along that continuum of coordination and collaboration, and it might be all the way to a fully integrated service where there's a number of different pieces that come together to create that whole, we have to recognize, again, the roles and responsibilities that we have. So if I'm going to be providing services, maybe I'm a counselor, a mental health counselor, and I'm providing some mental health counseling, I'm seeing the client in often a very narrow perspective. So I don't see that Albertan always in their normal state. And in order to understand whether or not the counseling is having an impact, I have to rely on others to tell me whether or not that impact is being had. Is the person improving? Are the behaviors escalating? Am I making a difference at all? I can't necessarily see that from the one-to-one interviews and assessments that I'm undertaking with my client. And so I have to rely on people that are working with that client to be able to feed information back to me. They become my eyes and ears. That's an important consideration in all of this, because we have that joint responsibility then to ensure that the things that we're doing are making a difference, that we are actually moving towards the outcomes that we've identified, and that through that process, we have to be able to share the information that speaks to those things. Now, when we talk about information sharing, we're not talking about everybody's files being open to everybody. We're really talking about what is it that is necessary to achieve those outcomes. Now, I mentioned that we have to be very transparent as well about what it is we're trying to achieve. That gets us into notification. Notification is a requirement under our privacy legislation. It means that we have a responsibility to tell Albertans why it is and how it is that we're going to manage their information, what information we are going to be collecting, what is our authority to collect that information, and how it is that we are going to be using it, as well as perhaps who it is that might be shared with. We do have some programs where the information never needs to leave the office because it's a very specific type of service that is being provided and nobody else is involved in that. But we have fewer and fewer of those programs. And so what we need to take a look at then is how do we ensure that there's some transparency, some clarity about the information that and how we're going to use it, the information we collect and how we're going to use that. In the past, we often, again, told people that we needed the information only for a program. We're not doing that anymore. We can't do that anymore because we're not able to only work in those very narrow approaches. So now we have developed what we call a common notification. And what essentially that means is that we have to tell Albertans that the information we're going to be collecting is going to be used to provide them with the services that they require, as opposed to just for a program. It's not just for age. It's not just for PDD. It's really to take a look at what are the services that you or your child or your youth requires, and how do we work together to ensure that we provide those services. The information will be used across all of those organizations. The common notification now enables us, and it starts to move us to open those doors more clearly. We have to be able to explain that to you. So when we first do a collection of information, we have to provide that notice. And now as we're shifting gears, it's fine for someone who's coming in the door as a new client that we are able to explain that to them. We have a lot of clients, though, that we've been providing services to under the old way for quite some time. So as we start to identify that this client might need some additional services, it's our responsibility to sit down with the client and say, not only are we starting to take a look at what is it that you require, but then how is it that we're going to actually work together to provide you with that? And you know that information that we collected under this program, when we collected the information under the Family Supports for Children with Disabilities, as your child is aging and moving into the next realm, the adult world, then there's a number of programs there that also need that same information. So some of that information is going to flow to those areas. And here's why. And if we do a good job of explaining that, then I think it's going to allay any concerns that might arise. But we have to be very transparent about that. We are, as a government, trying to become more effective and more efficient in that management of the information. And so sometimes what you'll hear about is that we're moving to a collect once and use where necessary approach. It is really moving towards that client-centered approach where we're focusing on the individual instead of focusing on our programs. And as an individual, what is it that you require in the way of supports? And then collectively, how do we provide those supports? So it is requiring, therefore, that we move that information to where it's needed in order to provide those supports. So I think I probably touched on a number of these things, but as we provide notification, and certainly as we roll out the common notification approach, and it has been used by PDD now for some time, we have to make sure that the messaging is the same. It doesn't matter whether people are coming in, and of course we're seeing ways, the way that we do business change significantly as well as a result of technology. We have applications that come in, someone comes in over the counter, still sees us in our office, but we're beginning to collect information through our contact centers and through the websites. We have online application processes for some of our programs. So wherever it is that we collect the information, we have to make sure that we give that message consistently, and that's part of the common notification approach that we're rolling out and implementing currently. Not just within Human Services or the new Ministries of Children's Services and Community Social Services, but really across all of the organizations that we're working with. We all have to have that common understanding about how the information is going to be used and be able to explain that to our clients. Now, one of the things that we've looked at as well is the consent process. So many of our programs in the past have looked at consent as being the only mechanism that allows us to share information. And when we started developing the strategy, that was certainly one of the things that was considered, that was identified as well as something that was a problem, because we have all sorts of different consent forms. So I may have a consent form that I've developed for my program area that has been developed for us, and I use that consent form and I go to another organization, and that organization says, it's not our consent form, sorry, that doesn't work, so you have to use my consent form. Becomes very problematic if you look at the number of organizations that work in order to provide the supports that we're talking about. And so one of the things that we started to look at then was, well, do we even need consent? There are times that we do, and there are times that we don't. And so we had to start to analyze that. One of the things that we've talked about is that we need to move away from using consent where it's not required. If we're going to be using consent in situations where it's not necessary, then we may run into other types of problems. So for example, if we have to collect information and we're going to do that collection of information under our program areas, regardless, it's not really consent. And to talk about informed consent, just the definition of consent itself means that I'm willing to give you the information that you require, and if I don't give that to you, then I understand that there are some impediments, if you will. So if I'm going to deliver a program, I need to collect certain information. I'm going to collect that information. It's not really a consent. It's ensuring that you recognize that in order to qualify, I have to have certain information, and we're going to get that information to provide you with that service. So it's more of an acknowledgement, and I think this is where it becomes really important to be transparent, that we can explain why the information we collect is going to support you or your child in the programs that we're delivering and trying to achieve those outcomes. Now, that's not to say that consent should be done away with altogether. We do have situations where we do require consent. And when we start to take a look at consent processes across the different pieces of privacy legislation, there's differences there as well. So we are working towards trying to develop some common templates that work across all the legislation. And we have developed some of those already. We're going to be looking at how do we push that out where it's necessary. Under the Health Information Act is where we have the greatest degree of rigor, if you will, in terms of the consent process. So we are going to use a consent form that meets those requirements, and then it satisfies all the other requirements under FOIP, under PIPA, under the Privacy Act by using that highest level of rigor. And as we develop those consent templates, we're going to be pushing them out. There are still some organizations that want to see their logo on it. This is my brand, this is my consent form. And so certainly as we push those out, then people are free to brand them as they will. But really, the consent is often used when we don't require it. And so that's why we talk about moving away from using consent unless you actually require it. It's not to say it's going to disappear altogether. And I've had discussions with staff who have said, I understand that I don't need this, but the only way I'm going to get information from agency ABC is by using consent. Well, the rolling out of the information sharing strategy is taking some time. We are talking about impacting on a lot of different organizations and a lot of staff working in those organizations. Even if we take a look at the world of health as an example, well, it's not just Alberta Health, it's Alberta Health Services, and they've got 120,000 employees. We are talking about a lot of doctors and nurses that are working on their own that are also subject to the HIA, and so other practitioners come into play. So we start to multiply that number exponentially. We have teachers in the education sector. There's 40,000 teachers around the province, and how many school boards and how many facilities themselves. Our own staff, we've got several thousand staff, and we contract with thousands of agencies across our various programs. So when we talk about changing the way we do business, it takes some time to get there. And in order to really have that significant impact is going to take a number of years. So if you need to use consent, go ahead and do that in order to get the results that you require. All I'm cautioning you, though, is that you make a purposeful decision about if you're going to use consent in situations when you don't actually require it. Now, there's also confusion that comes into play when we're talking about the types of consent. People often confuse consent to share information with consent for delivery of a program or a practice. So a consent to treatment is not the same as consent to share information. And I think that that's one of the areas that people get very confused about. So when people are signing a consent to my child receiving this service, that doesn't mean that the information can also flow, or that it is an information sharing consent. I may consent to a treatment and need to understand that in order for that treatment to be undertaken, there will be an almost automatic flow of information that is required in order to provide that treatment or to provide that service. So we do need to be clear about what is it that we're actually asking people to consent to, and how do we manage that. I've seen some very complicated consent forms where people sign 5 different times in 5 different places on the same form consenting to different things. So if it's confusing to us as staff, I can just imagine what it's going to be for someone who's receiving that service. Let's do better. We can do much better than that. Part of what we look at then is how do we become more effective in the way that we're managing those pieces. We talk about emerging practices as opposed to best practices. Quite often what we are looking at is doing something different. And that isn't always a best practice yet, but it's recognizing, I question even the use of the term best practice, because by the time it becomes a best practice, something else has come into play. However, we do need to take a look at what makes sense in the world of services that we're delivering. So part of that then is that notion of not asking for consent if you don't need it. If there's no legal authority to share information, then you might require it. And this is where we start to get into some discussions about the organizations that we work with. So as I look at the services that we're delivering, we have to work together with Alberta Health Services staff, and when I say we, I'm talking about the Personal Developmental Disabilities Program staff. We have to work with other practitioners in the world of health. We have to work with some of our agency partners, and we have to be able to identify who are those core players. And we often identify through service level agreements or through terms of reference or memorandum of understanding that here is the group of organizations that are going to be primarily involved in providing services to the individual or to their family. Those core organizations, if they are identified as public bodies or they have a contract with a public body, or if they're a healthcare custodian, if they're involved as a core service delivery partner, we may not need to use consent for the sharing of information across those core areas. But we may take a look at, Johnny needs some additional supports, and maybe it would be good for Johnny to access some services over here. So we're going to refer him over there. It's not a requirement per se, so we're not saying that he has to access that, but we just think that there would be a benefit. So by referring Johnny over there, maybe we want to share the information so that Johnny doesn't have to repeat his story to that agency, but because they're not part of our core partnership, then we have to use consent in order to share that information over with that agency. It doesn't require them to report back to us. There's no flow of information back and forth that is going to take place normally. There may be situations that arise. And so, again, when we take a look at those organizations that we work with, who are the core players? What is it that allows us to work together? May be different than some of our peripheral players that are involved from time to time with some of our clients. And we have to understand that there's a difference between that type of relationship. Gets back to understanding, therefore, our authority to collect, use, and disclose personal or health information. And this slide speaks to some of that, about what the public bodies can do and about what custodians can do under the HIA. When we look at consent, if you're going to use consent, then you have to, the best practice is still to use a written consent, although under some of the legislation now we can use electronic consent as well. But those are situations we're going to have to tease out and provide you more details on as we develop our practices and enhance our processes going forward. So I talked a little bit about the types of organizations, and that we're not going to open our floodgates in terms of information flowing everywhere. It really does become important to understand who's involved in this. And if you take a look at this slide, you'll see there's 3 circles. I mean, it could be 20 different circles, but there's overlaps between them. So we collect information to deliver the programs that we're providing under community social supports under the PDD program. Not all of that information needs to be shared with everybody. Maybe Alberta Health Services is also collecting health information in order to deal with some medical conditions that might flare up and to deal with ongoing issues that arise because of the disability or because of the treatment plans that are put in place. Not all of that information needs to be shared with everyone. We have service providers and agencies that work with our clients and that are dealing with the client on an ongoing day-to-day basis. The information that they collect sometimes is supportive of how they're going to work with that client. There may be nuances about dealing with an individual that they have to consider, and some of that information is important to share, but not all of it necessarily has to be shared with everybody either. What we're looking at really, if you take a look at that slide, is that nexus point, and that can certainly get smaller and larger depending on what the circumstances are. But what is it that needs to be shared between those organizations to achieve the outcomes that we're trying to achieve? As we do our coordinated case planning, then it becomes important to identify that and who's going to be doing what in relation to that information. And if somebody wants to access their information, how are they going to do that? We have to be able to think that through as well, so that if we're looking at information that is being shared, we need to ensure that we document how that information is being shared, who it is that we're sharing it with, so that if we get a question around that, we can provide that information to the client. So that if there's a change that takes place, or maybe we found that some of the information we collected, we recorded it wrong, even as simple as the birth date, we need to make sure that it's updated with the people that we share the information with. So we do have to have a record as to who it is that we disclose information to, who it is that we share information with, in order to deal with some of those types of issues. So the information, certainly, that we collect needs to be thought through in terms of the population, or the client population that we're working with. What is it that we need to know? Who it is that you're working with? Who is it that you are working with? Who are those service providers? Who are those other organizations? And having an understanding of that means often that you have to build a relationship. You have to understand where it is in terms of their roles and responsibilities and who it is that you're working with. As we started down this path of looking at information sharing, there's a number of things that we've identified that get in the way, and there's a number of things that really help support a good process. One of the things that really helps support a good understanding is relationship building. And what we found was that there's many organizations where there are very solid relationships between the different players, between the different organizations. I know Mary over in this agency, and I know that when I go to Mary, she has an understanding of how I work, the information that I require, and she gives me that information when I need it, because she knows how I work and what it is that we're going to use that information for. Well, Mary gets another job and leaves the office, leaves the building. So now I go to Tom, who's there, and Tom doesn't know me at all, and he's not as willing to give me that information. That's a problem that we find time and time again, that we often build relationships with certain individuals because we work with them on a fairly frequent basis, and yet we can't rely on that all the time. So part of what we're looking at then is, how do we build some of those procedural relationships? How do we build relationships between organizations instead of between staff within those organizations? And I'm not saying at all to stop building those relationships with individuals, because that's critical in terms of some of the work that we do. But expand that beyond that as well. Make sure that when you're working with Mary, that Mary's supervisors understand the way that we're working as well, and that there's that flow down from the top as well as from the bottom up, that we understand what our roles are, the respective type of information we require in order to do that, and then how it is that we can move forward. So that if Mary leaves and Tom comes in, Tom gets indoctrinated to the type of policies and practices that do allow us to work together. And that means having clarity around roles and responsibilities again. And what does that look like? When I take a look at the information needs as well, you do really have to understand what it is that you require in order to get to where it is you're trying to get to. So again, it's not opening the doors to all information, but if we have someone who is disabled and needs to move into the adult programs, again, it's not everything that we've collected in order to support them when they were a youth, but the fact that they have a disability, what is the nature of that disability, what are the supports and deficits that need to be addressed as they transition into adulthood. We need to understand that across the other adult programs so that we can better provide services in a streamlined way. Now, when we started developing this strategy, we had looked at a lot of different processes and projects to try to identify where are there some disconnects in the work that we do. As an example, when we looked at, we took a look at what was happening for the homeless population in Lethbridge. Fairly small population compared to some of the larger cities, and we were able to take a look at some of the clients there that were homeless and the types of issues that they were facing. What we found was that many of these clients had burnt their bridges. They were no longer welcome anywhere. They weren't welcome within some of our government work sites because they just created problems and people didn't want to work with them. They weren't seen to be a welcome person coming into emergency rooms. Of course, that's not to say that services were not being delivered, but people didn't really want to work with them, and the clients were often very antagonistic and belligerent, or other things would surface and make it very difficult to work with them. They were not compliant. In other words, they didn't follow our rules and policies and processes. So we started to examine what's going on with these individuals. And we tried to get information about them. We started to look at, are there assessments that might exist already in our various systems? In the education sector, did they go to school locally, and were there assessments about their behaviors on file there? From the medical community, were there assessments that were done there about how they were doing? Maybe they were a child in care at some point, so did we have information about them as a child in care or under the FSCD program? We found that there were some assessments. We found that there were organizations that didn't want to give us that information at all because they felt that they couldn't under the legislation, and the way that it was being interpreted at the time, they couldn't. However, we also found that there were often cases where there was no information about these individuals, and so we undertook to develop, to allow for some assessing of their capacity, and we did some neuropsych assessments. Looking at the capacity within Lethbridge, we couldn't even get all clients to go through that process there, and sometimes we had to bring them up to Calgary in order to do that. What we found was that 40% of that population, right off the bat, when we had that assessment information, had significant handicaps to the point that they were deemed AISH eligible almost automatically. They had no income, so that wasn't an issue, and the behaviors, the issues that they were facing, the things that were being identified in the assessments made them AISH eligible. That was huge for them, because what it meant was that now being eligible for AISH meant that they were also eligible for public housing. It meant that we could start to put in place some processes that would support them. So we were able to put in public housing, we were able to provide them with a steady income, and what we found was that there was a reduction in that emergency use need. So they didn't have to go to emergency health services every week or every other week. They didn't have to go in for emergency food vouchers. They were no longer needing to be housed in homeless shelters. We were able to start to stabilize them. And that 40% was just that initial piece. Since then, that number has grown. But it meant needing and being able to share certain information. When we had to go and get the assessments done, that extends that process. So if an assessment already existed and we could access that, then it helps streamline some of those processes. And that's some of the disconnects that we're seeing, was that we don't always think about what's the long-term need of the individual and how can we support that need. When we have an assessment that is done within any of our youth programs, including the schools, including our own programs within children's services or within community social services, we have to think about, so am I just fixing a Band-Aid right now? Am I just fixing a symptom? Am I just thinking about this program and it's going to end when the child turns 18? Is that disability going to continue? Are the needs and services going to continue? And in that case, am I looking at something that is much broader, that has to take them through their lifespan, if you will? There's other things that we found as we did some of these different tests. So we had another situation, Alberta Hospital Edmonton. And in that particular case, what we found was that people who were being admitted to Alberta Hospital in one of the units there, the social workers were having a hard time getting information. These are the hospital social workers were having a hard time getting information about the supports that already existed for these clients. And whether or not they had a place to go to, whether or not they had AISH, they couldn't get the clients to sign consent forms. The clients refused to sign those forms. And without those forms, the programs that they contacted were refusing to give them any information. So we sat down and took a look at what's going on here. And this involved some of our legal folks as well. So we had the legal profession involved both at Alberta Health Services, who's responsible for the hospital, as well as within our own department. And when we took a look at what's going on, well, first of all, we're looking at a consent process that really doesn't make sense. We've got clients that are being admitted into a mental health institution who are being asked to sign consent to share information. So the fact that they're being admitted, first of all, there's obviously some issues from a mental capacity perspective and their ability to understand what's going on. The chances are that they're pretty paranoid and really don't have a lot of trust in any of our programs and services and the way that we do business. So they're not going to be readily willing to give up information and to sign consent. If they are receiving programs, they might be concerned that they're going to get cut off those programs if they understand that to that degree. And even when they leave the hospital, they may be concerned and still refuse to sign consent forms because they may be afraid we're going to claw back their programs and their benefits and so forth. So we took a look at, do you actually require consent? Well, under the Health Information Act, what was happening here was really discharge planning. So from the day that the person is admitted, you have to start planning about how am I going to deliver the services in a way, how am I going to connect that individual within the community to get the services they require upon discharge so that they don't come back quickly. They may come back in the future, but let's try to minimize that. That's a health service. that health service means under the HIA, the Health Information Act, that they have the authority to collect the information they require in order to provide that health service. On the other hand, we have authority to provide information for a number of reasons. First of all, they can collect the information over in the hospital in order to determine eligibility for programs and benefits and provide for some of that service delivery. And really what we were trying to do was take a look at how do we make a seamless process for these individuals and what are the roles and responsibilities we have to work with that individual across the various organizations. So we're starting to build a collaborative or integrated service approach here, and that also gives us authority. Upon discharge, well, the HIA allows for information to be disclosed to someone who's responsible for continuing treatment and care. And when we looked at that provision within the HIA, it allowed us to recognize that some of these clients are going to be into supportive environments where there is a need to understand what it is that that person is facing and the supports that they may require. If you think about it, we see this in many other areas as well. So we have clients that are in shelters, and we're trying to move them out of the shelters into subsidized, supportive stage 1 housing where we can start to do a level set, deal with that type of issue, the housing piece first, and then we can plug in other services. Well, if you've got a client that is moving into that type of service, it's probably important to know whether or not there's any addictions or mental health issues or other types of issues that need support so that we're putting them into the right environment. So when we started to pull all of those pieces together, we recognized, that there is information that can be shared both by the social workers from the organizations that are providing some supports and from the social workers when that person is being discharged. But the second thing we had to look at was how do we get that message across? And really what people were looking at was needing permission. They wanted to know that it's okay to do that. So part of what we had to do then was create a permission slip, if you will, that we identified, and we had to indicate that this was approved by both the Government of Alberta as well as Alberta Health Services, that in these types of circumstances, the information can be shared. And then we had to educate people. So we had to make sure that our staff understood that it's okay to share information with the social worker at Alberta Hospital Edmonton in these types of situations, and vice versa. And the types of information flows then started to really have an impact for these clients. They were no longer being discharged into homelessness, and that really was the outcome that we were looking for. How do we ensure that there's a continuation or continuum of supports for these individuals as they deal with the different things that they're dealing with? We have clients that went into that facility who were AISH eligible, and the social workers would think, okay, I have to find out whether or not the person is getting an income, so do you have an income? And the client would say, yes, I get AISH. Okay, well, I don't have to worry about that. Well, even in those situations, we asked that the social workers confirm whether or not they were receiving benefits. And what we found was in a couple of cases, the client said, yeah, I get AISH. Well, when they contacted the department, they found, yeah, the person was AISH eligible, but the benefits had stopped because we lost track of that individual. We no longer knew where they were. We didn't know where to send the checks. We didn't know if they were still in the province even, and so their benefits were suspended. Well, when we suspend benefits, it doesn't mean that they have to start the whole process again. So knowing that the person had been admitted to hospital meant we could continue benefits for a period of time. And if the client was in there for a much longer period and we had to suspend, when that person left the hospital, we could do a rapid re-entry into the AISH program and start the benefits as soon as they were discharged. Instead of having the client maybe sent to a homeless shelter, and from that having to start the whole process again of looking for a place to live, identifying who they are, where they are, and letting us know so that we could start to issue other benefits for them. Now, we have many clients in those types of situations, and it really behooves us then to start looking at how do we support them in the best way possible moving forward. I'll give you one more example, and that is looking at some of the transitions. And many of these things that we're talking about really are transition processes between one area dealing with the life circumstances, perhaps due to age, sometimes due to the circumstances being driven by having to be admitted into hospital or whatever. The example I'll talk about right now, we tested something in Central Region, and that was the transition between the FSCD, which is the Family Supports for Children with Disabilities program, to the adult programs. So when a child is receiving FSCD benefits, then part of what we provide is transition planning. We want to make sure that we're helping the family to plan for the best services possible as they move into that adult world. We wanted to look at doing that in a seamless way as well, so that the client, so that the child or youth, as they turn 18, that there's no break in service and they can actually get the services that they require as soon as they turn 18. That means good planning. That means that we have to be able to help the youth and their family understand, first of all, what's out there and what's the best path forward for their youth's particular circumstances. And we have a number of different programs that might be available. We have of course, the PDD program. We have the AISH program, which deals with the income for those individuals. We also have individuals who might not qualify for AISH, but maybe they're deemed to be not expected to work and might qualify for an income support benefit. We have some individuals that might need to have a public guardian or a public trustee involved. And so we have to be able to take a look at how do we best support that individual to move forward? What is the type of information that needs to flow across that? So what we did was a test, again, a pilot, focusing on 25 families in the Central Region. There were more client families that might qualify, but we decided to keep that number small, and we started to look at, so what does that mean in terms of our processes? Well, as we started to examine that, one of the things that was identified was we needed consent to participate. Not consent for disclosure, but consent to participate, because we were not choosing that whole population. We were saying, do you want your youth to be part of this program, or this pilot where we're going to test these things out? As we did that, then we started to look at, so what now needs to flow in the way of information? And our legal folks said, well, you need to have consent to share information as well. And we said, well, we're not, why is that? So they felt that there was a need to consent for the information to be shared because this was a pilot again. And we said, okay, fine, we'll go through that process. And we started to look at, so what information actually needs to be shared? Because this is a youth who may have been receiving services for a long period of time, may have all sorts of areas where they need some supports. They might need, in some cases, bathroom supports even, to the point, or to other situations where they might not need that level of support. And as we started to look at who is it that we're going to bring in from the adult programs to provide information, then we're looking quite often at intake workers, because they're the ones that are often that initial connection with our programs. So when the legal folks looked at that, they said, well, let's look at the job descriptions. And the job description said, well, this person determines eligibility. So that means they only need, in the AISH program, they may only need this snippet of information. For PDD, they need this information over here, and so forth. And we said, well, no. The reason we're involving people from the intake is not to determine eligibility at this point. That will come later. It's really to provide information overall about the types of programs and services available through whatever program they represent. But the other thing within these workers, the intake workers, is that they understand what else is out there. So we may have a client that approaches us and applies for a program, doesn't qualify, or even if they do qualify, they may benefit from other areas of support. And the the intake workers often have a good understanding of what's out there and what's available and would provide that information as well. So we wanted to know more specific, or more generally, the types of needs that the youth had, and being able to share that with all of the intake workers from all the programs so that together they could do a good job of sharing information. Well, because their job descriptions really didn't speak to that, and because this was a pilot, that we hadn't changed job descriptions, we had to narrow that down, so we couldn't share everything. So then we would bring the family in, and we would have the various workers there from the various programs. And of course, these parents have already signed consent to share information, signed consent to participate. And then they come to the table and they're asked to tell their story again. Well, why are we telling our story again? We've already given you that information. We've already shared, assigned consent, and et cetera, et cetera. So lessons learned there that we need to take a look at all of those pieces, including things like job descriptions. As we move more and more into integrated and collaborative services, we have to make sure that the workers, whatever it is we're providing in the recruitment process and the resources and tools that they need, that we speak to those types of things as well. Now, we did have a family that chose not to share their youth's information. Well, then they couldn't participate because the whole idea was to do planning based on what are the youth's needs. So for that individual, they couldn't participate and the planning couldn't take place in the same way. Not to say that planning doesn't take place, but it was a lot narrower. So the outcome overall was very successful. People felt that what we found, of course, was that the information did flow, worked through some of those speed bumps, but we were able to then take a look at what are the best programs for that youth and streamline the process. So when the child turned 18, they had already done their application processes and there was no break in service, that they got the services that they required under the adult programs, which of course are different than the FSCD program. For that family that didn't participate, they couldn't do that. So there was a break in service. Now, when a child turns 18, they become an adult. And unless there's a guardian or a public adult, or either a public guardian or an existing guardian who steps up and becomes a guardian or a trustee, then that child technically is making their own decisions. Now, it's not that the families are moving away from supporting their child, of course, but it does just add another layer in there, another wrinkle. So now, as we've looked at that, we've built in transition planning into the FSCD program. And we're looking at that across all of our programs. How do we ensure that there's seamless and better approaches to working to support the family, to support the child across all of the programs that they require access to? That means we have to work together to plan. We have to understand what are the areas that the client needs some supports in, what are their deficits, what are their strengths, what are the things that they're capable of doing, where we don't need to step in to the same degree, maybe to some degree, but not necessarily as fully involved as we might be with others. And then how is that information going to be necessary as they move into the adult world? From the adult world, if they become a senior, what information might need to flow there? So all of these transition processes we're examining and looking at how can we be more effective in sharing the information that is necessary to support them. As we do that, then it becomes really important that we have that good understanding and that we are able to explain that to our clients, that our clients understand that the information that we're collecting is not just for dealing with a Band-Aid at times, but really taking a look at how do we support them through their life cycle if they're going to be involved with us for a long period of time. So part of what I've been talking about is described on this slide here. It's really taking a look at how do we take our policies and our practices and move that into the delivery of services. And it does mean having those meaningful conversations. It does mean having a dialogue not only with our clients, but also with each other, so we have a good understanding about what are the different roles that we play in that client's life, and what is it that we require to be supportive. It also means starting to understand how it is that we work with information. So when I think of one of the integrated services that was developed in Calgary and is now being pushed out across the province between health services and PDD, one of the things that I learned was that, and one of the initial stumbling blocks was language. Well, I mean, we've seen that time and time again, that we all have different definitions for things. So if we don't talk to each other and start to examine some of those definitions, then we're not going to be able to move forward very fast. In this case, I understand that there was some discussions around rehabilitation. So from the health perspective, rehabilitation meant this, and they thought that PDD was taking care of that, and therefore health services didn't need to get involved. PDD, on the other hand, was saying, well, no, the rehab that we're doing, we think that health services is doing that rehab, and they should be the ones that are driving that. So getting together started to discuss, we're talking about different things when we're talking about rehabilitation. And they need to be working together, but they are different components, and we do have responsibility for each of those components within our respective organizations. So now how do we work together to then make that more of a support blanket for that client and be more effective? It means starting to examine some of the things that we put in place. So we contract with agencies. Those agencies may contract with multiple service providers. If we're providing services through that agency, through these different organizations, maybe we need to start examining what that means for that agency and how they can share the information across as well, so that it's not just a agency gives us the information, agency gives health services the information, we have to connect over here. It may have to be a three-way flow. Those are some of the things that we're putting in place right now, where we're examining more the frameworks that are going to support these different collaborative service clusters or approaches. And you, as a service provider, have a role in that, in understanding and being able to articulate and explain what this means from your perspective as well, and how are you working with us, and what information do you need in order to provide for better outcomes. We may have to then take a look at our contract language and our different resources that we make available and how we engage with you. So this work isn't done by any stretch, but we are certainly making strides and moving forward in order to take a look at, again, supporting those best outcomes. And as we look at that, then we really, as we open ourselves to collaboration more, it is recognizing that we all have a shared responsibility. We cannot do everything through our own organizations that a client requires most of the time. There may be some instances where someone needs a benefit, and that benefit, once it's issued, that's all they need, and we never see them again. But many of the clients that we deal with, many of the vulnerable Albertans that we deal with, and quite often, to be honest, I think we're all going to be in a vulnerable state. So this applies as much to us as it does apply to the Albertans that we provide services to. As we deal with those Albertans, we do need to understand what it is that they're facing and being able to provide information about how we're going to work with them. So if we have a shared responsibility to provide those supports because we can't do everything, then that means we have to work together. If we're going to work together, we have to talk to each other, and we have to be able to share the information. Now, when you look at the privacy legislation, there's a couple of things in there that often stand out, and I think this is where sometimes that whole notion about not being able to share comes forward. Because under the existing privacy legislation, we actually can share a lot more information than what we have been doing in the past. So a couple of things that stand out are, first of all, that we have to provide the least amount of information possible. If you think about that, how do I make a decision about what is the minimum amount of information that you need in order to do your job? If I don't talk to you, how am I going to know that? How am I going to know how you're going to use the information if I don't talk to you, if I don't understand your process? If I decide on my own that I'm going to just give you some nuggets, is that enough for what you're trying to do? We had a situation where we had an organization that provides triage services to individuals that phone in. So it's a call center, and when the people phone in, then there's a triage process, and in that triage process, people were able to readily identify that this is the sort of condition that you've got, and maybe here are some steps that you should be taking. So from a health perspective, when they're looking at that, there was a sense that in some cases that the child that the person was phoning about maybe had been the subject of abuse. Well, under our protocols, there is a requirement for these individuals, for the staff working here, to provide a report back to Child Abuse Hotline, indicating that they're concerned about an abuse situation. So the staff working there would call the hotline and they would say, so here's the name of the child, here's why I think that they've been abused, and here's the first name of the parent, but I can't give you anything more than that. Now, not all of the staff were doing this, but some staff were, because they were concerned about a couple of things. As we dug into it, we found, well, one of their concerns is that the minimum requirements under the Health Information Act prevented them from giving anything more than that in their view. The other big piece, though, was that they also didn't want for the person who's phoning in to stop phoning in. And they felt that if they gave us too much information, we would show up at the doorstep and say, this organization contact center called us and told us that you're abusing your kids and we're here to take them away. Well, it's not how we work. But if they don't talk to us, then how are they going to know how we work? If we don't talk to them, how are they going to know that? So we explained that, well, first of all, we don't provide information about who calls into the hotline. We do not just show up at the doorstep and base it all on that one conversation. We start to gather information from other supports around that family. And from there, start to make decisions about how we're going to engage with the family and how do we then best support them to do better. We also took a look at those nuggets. So how do you know, as a person working in a contact center, what I need? You're making assumptions about what I require. And in order for me to do my job, I actually have to know the last name of that parent. I have to know more information than what you're providing to me. So that's an example of where we have to really test our assumptions. We're not always in the best position to understand or to know what it is that you require when you're asking for information. I also need to know how you're going to manage that information. So if you're requiring certain information, but your process of managing that information is really poor, if you don't have locked filing cabinets, if you don't have a way of securing the information, I'm not going to give you that information as readily as if I understand that you've got a fairly good process in place. So that means dialogue. That means talking to each other. That means talking between organizations, not only looking at the roles and responsibilities, but how do we manage the information and how do we work with that information? What are those roles? And that really gets back to that need to have discussions, to need to be clear to what is the things that I need to do to provide supports, what information do I need in order to do that, what information do you have? The other thing that comes in from a dialogue perspective is that ability to understand I guess the circumstances that are driving that sometimes means that I have to give you information to get information. Because I may approach you and say, you know, in order to provide better services to Bobby, I'm going to require some of the information that I think you have. And you take a look at what you've got, and you're looking at the things that you're doing with Bobby, and you think, well, no, I don't really need to share any information. I don't have any concerns. I don't know what you're going to do with it. So then I'm going to be in a position where I'm going to say, well, here's why I think I need the information. Here's what I know about Bobby. So I may need to give you some information in order for you to start to put the pieces together and provide that information back to me. So again, that reinforces that need for dialogue, that we have to be able to talk to each other and explain why I need certain information. That shared responsibility then leads to shared action, and that shared action then should lead to better results for our clients that we're providing supports to. And we have that sense of ownership, we have that sense of commitment that I talked about earlier, that everybody expressed. We're very committed to doing the best job possible. But in order to do that, we have to be able to share information. And that has to be built on a foundation of trust, understanding, and really being able to explain and identify what is the linkage between the information we're collecting and the outcomes that we're trying to support. That means critical thinking. That means pulling in the pieces that you need, the skills that you have, the supports that you require, identifying all of that, and then moving forward. Now, we've been working on this, as I mentioned, for a number of years now, and it is a slow change. It is a process to get there. We're talking about some significant shifts in the way that we do business. So we're moving away from a fear-driven approach. People are afraid of making mistakes. People are afraid they're going to get in trouble. Maybe they're going to get in trouble with their supervisor or their manager for making a decision that they maybe shouldn't have made. Maybe they're going to get in trouble with the commissioner's office because, you know, that nasty privacy commissioner, they've got fines that are being levied for inappropriate information sharing decisions. Well, we've been talking with the Commissioner's Office, and the Commissioner's Office is very much very supportive of the overall approach and very supportive of ensuring that we're doing the right thing. So when people are getting fines for snooping, it's because they're being stupid. It's because they're going in and they're taking a look at their ex-partner's ex-spouse's new partner's health information, as an example. If you're going to do that, you have no authority to do that in the first place, and you should get caught, and it is being stupid. What we're talking about is really sharing the information in the best interests of the clients that we support. And there are provisions even within the Health Information Act and the FOIP Act that if you're making a good faith decision to do things because it is in the best interest of the client, you're not going to get in trouble for that. And the Commissioner's Office is not going to come after you. We need to make sure within our organization that our managers, our supervisors also embrace and understand this. And so that's been part of our strategy, is rolling this out not only from the bottom up, because I think that as professionals, most professionals get that. They understand why it's important to talk to each other. But we have to make sure that the management layer also understands and promotes that approach. We also have to develop resources. So for a number of years now, we've been developing different resources that are available to everybody. So this is a slide of our website. And on the website, we do have resources that have been developed. I mentioned earlier that decision tree, and the decision tree is up here. There's a different version of that. We also have courses on here. So there are some online courses that can be taken by anyone, whether you're working for government or outside of government, whether you're Joe Public. You can take a look at what it is that we're saying in these online courses. So you can go in, take the course, and from that there's different examples and learnings that apply here. We also, as we continue to work through this, we'll be adding more resources to the website here. So certainly keep an eye on that, because we do add more and more resources. And as organizations identify where there are problems, there's also a help desk function on here, so you can connect with us. As we take a look at the help desk as an example, one of the things that we identified early on was that people do work together. But as they work together, they run into questions, and they go off and they ask their own organizations, can I do this, and can I do this? So you've got 3 different people from 3 different organizations that are working together that need to have an answer to a question. They go to each of their help desks and they come away with different answers. It's not very useful. We have to make sure that we're consistent from a support to you as your staff perspective. So part of what we've put in place now is a community of practice where we have some of the larger help desks that get together on 3 or 4 times a year and discuss some of those things that we're seeing and some of the ways by which we can become more consistent. So if you're going off to the help desk in Service Alberta for FOIP or PIPA, if you're going off to the help desk in Alberta Health or Alberta Health Services, if you're going to the help desk in some of the larger school boards in Calgary and Edmonton, we get together and we discuss some of the things that we're seeing, the approaches that we're talking about, the path forward, and how we're going to interpret legislation so that we do get some consistency in the discussions and the issues that arise. So our information is on here as well. You can connect with us either by phone or by email. And as those things come in, then we take a look at how we're going to manage that consult and who do we need to engage with. So the more information you can give us about what the issue is that you're facing, then the better we can do to coordinate a good response across all of the organizations that are involved. So certainly do feel free to connect with us as you see fit, as there are questions that arise. Of course, I would encourage you that the first place that you should connect with is your program managers, so that the questions arise, feed up through the organization that way, and so that we can take a look at addressing those types of issues. As we see more and more investigations take place, as we see more and more reviews of the processes that we have in place across all of our organizations, we find that there is a very significant focus on the need to ensure that information flows where it needs to. So if we know that someone is requiring certain services and we don't share that information with someone who's supposed to provide some of those services, how can we expect them to do better? That's the intent of this, is that we need to work together to identify what is it that the Albertan requires, what services do we have that might support achieving those requirements, and then how do we work together in order to do that best job possible. That's really the intent of the information sharing strategy, and we are working across many programs and organizations in order to get there. I'm going to stop here and open the door for questions. Thank you.
We have a question here. When will we be able to see common templates that have been developed for consent across the programs?
Great question. So we have developed templates. We have developed a number of guides. We have a transition guide that was developed focusing on the homeless sector, and within that we did develop a template so we could test that in different places. In the homeless sector, we're dealing with organizations that are subject to FOIP, of course, our own public bodies, our own department. Seniors in housing is involved. The housing management bodies are involved, so they're all subject to FOIP, and they all come under that, so we meet their requirements. We also work with Alberta Health Services in that, and Covenant Health Services and other health practitioners. We work with police services, and police services are also subject to FOIP. Even the RCMP has recognized that, it's been recognized that through the contract we have under the Police Act that they are a party to our organization, our processes, and are involved in many circumstances. Not just from a criminal investigation the police services are involved, it's often community policing, dealing with things like nuisance crimes and so forth because people don't have the ability to meet their needs. So we did develop a template there, and that template is being used, being tested, and we are finding that it works well. So our intent now is to broaden that and to push that out more broadly. So we do have the template available to other organizations. As we, what we need to do now is get the buy-in from the senior levels within organizations to support that. And I suspect at the end we're probably going to have a few different templates, but we should be able to narrow that down significantly. So the template actually is up on our website, and people can use that template, but we're still in the process of validating it, if you will, with some of the larger organizations and getting a comfort level around that. But it does meet all the requirements under all the privacy legislation.
Excellent. How can we enforce the sharing of information? It's very common to get no paperwork when retrieving someone from certain hospitals.
To get no paperwork when? When
they're retrieving somebody from certain hospitals. So how can they enforce the sharing of the information?
So there is, that's a great question because people want to know that they can actually get what they need. There is no way of enforcing that. However, part of the messaging that we provide is that you're as accountable for what you don't share as for what you do share. You do have to make good decisions, and you need to have that information. But you need to explain why you have to have that information. And you can certainly talk to us about if there are trends that seem to be emerging, if there are certain organizations where you're seeing this to be more of an issue, then by all means connect with us. We have been working very closely with Alberta Health Services. They are one of our partners. We have a number of committees that are struck in order to support this work going forward. So we have a coordinating committee that I chair that has representation from each of the ministries. And through those sectors, they also have involvement. There is a health services sector, and Alberta Health Services is part of that. And we've been working very closely with the folks in the Health Information Act, the FOIP sector within Alberta Health Services. They've gone through some changes recently. They have a new person responsible for that area. We're going to be meeting to talk about how can we ensure that we, from a principle-based perspective, support this work moving forward. So it is a culture shift. It's in many different ways. We're talking about not only moving away from a risk-averse environment, we're also talking away from moving to not a you can share, but you should share, you must share information if it's necessary to support those outcomes. That's a big shift for a lot of people and for a lot of organizations. When we look at risk, we have to look at risk not only from the perspective of, is there a risk of a privacy breach, which is often the biggest issue? Is there a risk to not being able to provide services we require to be providing? Is there a risk to health and safety issues because we're not sharing information? Again, I mentioned that there's a health and safety clause in all the privacy legislation. We can use that. I would much rather be sued because someone says I breached their privacy and averted something tragic happening. And we've seen too many situations where that has happened and it shouldn't have happened. So it is, though, it's going to be an iterative process, and it's going to take some time to get there because culture takes time to change.
Is there any work being done on sharing information with justice? For example, when individuals are transitioning out of correctional facilities?
That's a great question. Yes, we are working with justice. I mentioned earlier that we brought justice on in 2016. We brought them in, got them involved because we knew that, first of all, we have many different programs where we overlap with the same clients, and we're seeing the same types of issues, whether it's addictions and mental health issues that get them in trouble with the law, to other things as well. So Justice is one of our partners. We are working very closely with them. There is work that they are doing also focusing on a client-centered approach to how do we support clients. And of course, they have a lot of people that are moving out of jails that need health benefits, that when we started talking about the transition planning, for example, to deal with the homeless sector, what we heard was, well, even though Justice contracts with Alberta Health Services to provide those health supports, they weren't getting information from the health side to support those clients while they were incarcerated. They needed that information. They also said, well, you know, when the person is going to leave our facility, they're no longer in jail, we totally lose control over them unless they're under probation. And so we can't require them to do things. That doesn't stop planning, though. You can plan in advance for supports to be put in place. And yes, there will be situations where the person chooses not to take advantage of that. But at the same time, if you start the planning, start the dialogue, start having those discussions, then yes, we can start to deal with some of those issues that lead to the continuous recidivism where we see that person cycling back and forth continuously, whether it's the correction system or the emergency health system. We can reduce some of those things by putting things in place, but it does mean talking. So I'm happy to say that Justice is involved. They're very excited. They have a number of programs and services that they're looking at. How do they do a better job of connecting with all of the supports outside? Again, it will take some time. They also have the added complexity of the court processes and what the court document requirements are. And youth criminal justice system becomes even more complicated, but we are making some advances there.
What is the current best practice for consent in transition planning?
The current best practice for transition planning, I would say it's or emerging practice. I would say that, again, it's taking a look at what is it that needs to be done, with whom, and what information needs to be required to be flowing forward. And it depends still somewhat on programs and services. So we have kids that are in care in child intervention. We have kids that are in care that receive supports from FSCD. Under the FSCD policy, there is a change that has taken place, so that transition planning does take place now without consent. What it means is that we very clearly articulate to the parents that the information that we have about their youth is going to be used in that planning process so that we can give them the best information possible about what's out there for them so that they can make good, informed decisions. And I think that that's the key critical thing that needs to happen, is that we can explain to individuals, to their families, how this helps them. How does this information flow, this sharing of information, help them, help their child, help them as an adult in order to do better? So there are programs such as FSCD where that has now been built into the process. There are other programs such as moving into the AISH world where we are looking at how do we make that more effective. And part of it is going to rely on the implementation of what I talked about earlier, being the common notification. We're just in the process of implementing that across all of our programs in children's services and community social services. And through that, that starts to open that door. But it means training our staff to be able to understand and explain how that works, how that opens that door to better supports.
Do individuals need to provide consent for agencies to participate in a collaborative planning meeting?
So one of the things that you often hear about when you talk to FOIP people, to privacy people, is an answer is often that depends. And it's not a great answer, but sometimes these things are very case specific. What we're trying to look at is where are the trends and how can we examine some of those trends, what are the types of clusters where things happen, need to happen, and so forth, and then talk more generally about the sorts of things that can go on. We have situations where, again, the agency may be operating under a contract to our organization. So if they're working under contract, we have to make sure that the clients that we're dealing with, the adults, the children, the representatives, understand that we have this relationship with that agency and what is the role of that agency in the delivery of those services, and this is why they have to be at the table. We may have some other agencies that we are not contracting with where they are able to provide some good supports, and in those cases we may need to have consent. So it is somewhat case dependent, but if we have a relationship where we are asking an organization to provide services on our behalf to those clients, then they're kind of automatically deemed to be an employee for the purposes of the information flow. They're deemed an employee for the purposes of FOIP. They may be deemed under the HIA to be an affiliate or an agency representing that organization as well. So it depends in part on what is the relationship we have with the agency, and if we have a formal one, well, actually even volunteers can be acting on our behalf, then we just need to be able to explain that to the Albertans we provide supports to, and this is why they should be at the table, so that you don't have to repeat the story over and over again.
Were any advocacy groups or people with lived experience involved in the development of this initiative?
Yes, great question. One of the things that we talk about is the consultation process and making sure that moving forward we consult as needed. So when we first developed the strategy, we knew that there was a lot of things going on from an anecdotal perspective, and we couldn't necessarily just develop something just based on anecdotes. So we did a lot of consultation. We consulted with many organizations in government and outside of government. We had online consultation processes, and some associations and representatives for different groups were able to participate through those consultation processes. We also did some interviews with different groups that work together. We did some different focus groups with different organizations, probably half a dozen different focus groups that we ran, and we started collecting information from all of those areas. As well, we started to take a look at some of the consultations that had taken place previously. So what is it that gets in the way? What information was gathered during the social policy framework process review, and how did that information support the overall direction that we're moving in? We also do make this available to all and sundry by putting things up on our website, so we want to be transparent about that. Going forward, we do know that we want to open the door to anybody coming forward with concerns, areas that maybe aren't being addressed, that should be addressed, and our door's always open for those sorts of approaches. And as we start working more and more with the agencies, which is going to be our kind of a next phase, we've been focusing primarily on government organizations, but the training is available to agencies. We recognize not all agencies need to share information. If we're talking about Bob's resume writing service, chances are they'll never share information. But an outreach arm for a community-based agency that provides supports to a family, maybe they need more information than we've been giving them. Maybe they have more information than they've been giving us, and we need to start to understand how can we do a better job by working with them and broadening some of that sphere. As we do that, we will be looking at connecting with different associations that represent the agencies, different stakeholders, and getting inputs about how we can do a better job about some of that. So we certainly continue to open the door. We have done some consultation, and we're always ready to receive inputs.
If our program is a potential first point of contact with persons with disabilities, is it our recommended that we gather information which may indicate a need for further services, or are we restricted to asking for only program-specific information?
Without knowing what type of organization you are, so if you're a government organization, I think that I think that Whenever you're involved with a client and you're going to be providing some supports to that client, you need to understand where is it that the client's going to require supports, and for how long and in what areas. So if we're talking about somebody who has an immediate need for something that is short term that your program can provide, then that may be all that you need to talk about. But if you're looking at providing some supports to an individual or a family that is going to require long-term supports where you can gauge that there's going to be involvement from others, then that's where we need to start to look at, so what is your involvement with those other organizations? Is there already existing a framework by which with whom you work is identified and the type of information that should be flowing? And then you can build from that into how it is you're going to support that individual. If there is no framework, if you're just aware that this client needs some additional supports, you can't go out and just collect the information because of that and then look at who can I now share that with. You need to start thinking about more strategically. So what is the type of clients that we're dealing with? Who needs to be involved with that? And maybe I need to now make some connections with other organizations to provide that. We are just about to launch an information sharing guide to support service delivery design, where we start looking at how do you build that framework? Who are the organizations that need to be engaged as you develop that? What are the processes that might need to change as you start to develop that? Because what we find is that sometimes we do a good job of identifying, so this is what we need to share in order to provide certain services, but we don't do anything about the foundational pieces underneath that. And so when it comes to actually sharing the information, maybe we need to share it electronically, maybe we can just have a conversation. Maybe there's some practices that as an organization we have that get in the way of that. One of the things that is often recommended as we look at the flow of information is a privacy impact assessment, where we take a look at, so do we have the authority to do these things, and how are we going to manage the information? We provide that privacy impact assessment, or PIA, to the Commissioner's office. But as we develop those, sometimes we find that organizations that are working together, they all decide they want to do their own. So we might have 2 or 3 different PIAs that are going forward on the same thing. That doesn't make sense either. But that's our practice, that's our policy. So some of those underlying types of things we also have to examine, and can we do that differently? What are we going to do when a client comes to us and says, I want a copy of my file? Well, if that file is held by 3 organizations, how are we going to manage that? And we have to be able to provide that and some guidance. We have to think those things through. So some of that process work is under development, about to be launched, and that will help, I hope, guide some of the discussions that still need to take place.
Will service providers be expected to develop policies that show how they are using this new information on sharing systems?
I think that we have to always be able to articulate how we use information, and that we should have practices and processes that support that. So if we are sharing information, then we have to document that we have disclosed information. Policy should reflect that as well. Our practices should be underlining that. As we talk to clients about how we're going to use their information, what do you base it on if you don't have a policy or a practice that speaks to that? Now, some of that may be driven by, again, that framework approach. So as we enter into a framework and we've defined what our roles and responsibilities are for the different organizations, you may not have to do that individually as an organization because it's all there. But you have to be able to point to something. How do you train your staff if you don't have something to point to? By word of mouth, or by, this is what I do, and Joey over here maybe does things differently. And so we do have to ensure that there's some consistent approach to managing that. And that may mean that we have to look at what we have in place, tweak it if necessary, or point to something else that becomes kind of a layer that we work from.
I had an individual compromise my health information. I was notified, however, I'm not allowed to know who this individual is. Why is that? Great question. People do feel sometimes that their information has been breached, and sometimes breaches do occur. We do have individuals who do stupid things. People are human. Doesn't excuse it. Do you have a right to know who has access to your information?
I think under the legislation there probably is a requirement that, at least organizationally, that we identify where your information has gone. If someone has breached your privacy as an individual, those are complaints that can be taken to the Commissioner's office, certainly, and they will do investigations. As an organization, if I know that somebody has accessed information inappropriately, then we have an obligation to investigate that and to take the necessary steps, and that may also include going to the Commissioner's office. As to who it is, I think it may depend on the organization and their policies and practices. I don't think that it's legislation that gets in the way of that. There are people that are charged as a result of doing things inappropriately. All of the charges that have taken place have been under the Health Information Act, and they've all been because someone has been stupid. We have to be careful that we, again, understand and explain how the information is going to flow. We have had situations, for example, where we have approaches to working collaboratively together, and we are supporting Johnny through a number of different approaches, and some of those approaches become very successful in dealing with some of the issues to the point where a new assessment takes place and we find that we can scale back on some of the supports that are required. Well, some people get really upset when we scale things back because they see that it's, well, it negatively impacts them from their perspective. What it is really is recognition often that that person is doing better. The client is doing better, the child's doing better. And by pulling back some of those services, it's because they're not as needed. If that's not the case, then we need to have the information about that. But sometimes that becomes in someone's view, the reason we pulled back the services is because we breached their privacy. We shared an assessment when we shouldn't have. We have to make sure that up front we explain how all of that works so that people coming in the door understand that we will be using the information to provide those supports, and we have to monitor those supports, we have to assess those supports, we have to make decisions based on those assessments, and sometimes they're going to be that we increase, sometimes they stay the same, sometimes they become less. That's not a privacy breach. That's needing to speak to things well. So we have to be careful about what we talk about in terms of breaches as well. And I don't think that's where you're going, but just as a general comment, we need to be clear how we use information.
If a PDD client has a public guardian, who should be providing consent to outside agencies, the guardian or myself, their PDD coordinator?
I think that probably depends in part on what the guardianship agreement, what the guardianship order says. So most of the time, the public guardian, if they have responsibility for decision making around the supports for that individual, they should be the ones making those decisions. But really, that should be, as much as possible, that we all work together towards the best outcomes for that client. So that means developing relationships. And if you don't agree with something, it means having that discussion with the guardian and with whomever else is needing to be involved in that discussion about why you think something else should happen. But it will depend quite largely on what the order actually states, as I understand it.
Is there somewhere they can email to access this PowerPoint?
Good question. We will make this, I believe that this PowerPoint and the entire, so this session has been recorded, and as I mentioned at the beginning, the session is going to be made available on the website probably within a couple of weeks, and the PowerPoint is part of that. If you want the PowerPoint by itself, separate from that, you can certainly connect with us. We will make it available. And who you connect with can either be through the hosts of this program, or our information again is on the slide of resources, and you can connect with us directly.
If verbal consent is provided over the phone to share information with service providers, is it appropriate to accept that as consent and share without written documentation? Is there a follow-up form from clients required to obtain written consent?
Great question. Under the FOIP Act, there is capacity to do both oral and electronic consents. However, there is a requirement to document that consent and to have something that you can go back to. So as you look at, as a public body, as a department, for example, we have to make sure that oral and electronic consents meet certain criteria, and there is a process by which we can identify the circumstances in which we'll accept verbal consent. That needs to be approved through both the program area as well as the FOIP office here in Community Social Services. And once that process is in place, there is a requirement to document that you have had verbal consent and when and what it is that has been consented to.
Okay, this is the last question. Service providers under PDD may use subcontractors for a part of their service referred to as residential services. What information will the service providers be sharing to the subcontractors tie this into a recent fatality inquiries?
So when we contract with an organization to provide supports on our behalf, then we have, through the contract, we identify what needs to happen in the way of the services and how you manage information as well. So there's often requirements around what information you're going to manage, how long you're going to be keeping it, how you have to manage it, and so forth. If you subcontract, and our contracts often speak to that as well, then you have the requirement as the agency that is contracted with to ensure that the same rigor and the same requirements are passed on to the agency that you subcontract with. So, and there are maybe circumstances where we don't allow subcontracts to take place. But if you do subcontract with someone, they become your employee from an information perspective, and they need to have the same rigor around how they manage that information applied as you do as an organization. We hold you accountable when we contract with you. From an information management perspective, you have to hold that other organization accountable. There are always going to be situations that we cannot foresee, and so we have to think about those things as much as possible in advance. When we're looking at information, especially health and safety type of information, if there are risks that we're aware of, that you are going to be dealing with that individual and need to be aware of those risks, we have an obligation to pass that information on to you and work that through. And similarly, you would have that requirement, I think, to pass it on as well. But let's talk about what those things are and how we manage that, and then how do we then ensure that you have access to what you need and that the organizations you work with have access to what they need. Certainly critical from a health and safety perspective, but I think equally important from just how do we provide the best supports possible going forward. So I do want to say thank you for the opportunity to present today. Thank you for the great questions. And I'm sure that there is, like always, going to be questions that you think about after the fact. You can connect with us, again, if you have questions. If there are issues that you're seeing that arise that are trends, especially if they're trends, if they're one-off, we can deal with those as well. But make sure that you bring those questions up through your organization as well, so that we can look at and ensuring that, you know, if this is something that we're seeing more than once, that we address that as globally as possible. So I do want to say thank you. Thank you for joining us today. As I mentioned in the opening, today's webcast is part of the Government of Alberta's Community and Social Services Learning Series, which runs the third week of each month. The current season is wrapping up this month, so this is the last one for this season. But we will be back in September with a new season of webcasts. So I would encourage you to check your email or go to CSS Learning Series.ca regularly for updates. And you can see that link on the screen in front of you. This series covers topics from PDD, like the one you saw today, but there are other series that talk about Employment First, the Alberta Brain Injury Initiative, or ABII, Fetal Alcohol Spectrum Disorder Initiative, FASD, and of course the Office of the Public Guardian and Trustee, the OPGT. So again, thank you very much for your participation in this, and feel free to connect as you need. Thank you.